You click to see the difference between a personal injury attorney and a car accident lawyer, and here's exactly what you'll get. The Nevada truth for a state with a high volume of serious crashes, especially in Clark County.
Red Rock Injury Law, Las Vegas. Rock! Solid recovery! Solid recovery! Rock! Red Rock!
We'll map why the license is the same, what actually separates a great auto advocate, and how these skills change your settlement by focusing on proven auto-specific competences, not vague marketing labels. Specifically, you'll see fault battles under the 51% bar, how DUI crashes open punitive damage leverage, and why AB 398 matters at the negotiation table, and the must-ask coverage questions about UM/UIM stacking and MedPay. By the end, you'll have a 60-second script to vet any attorney and why labels don't win cases. So let's talk about why labels don't win cases in Nevada and what actually drives outcomes. If the license is identical, why do two lawyers with the same card get you wildly different results on the same crash? In Nevada, the titles are branding. The state issues one law license to practice as an attorney, and there's no separate car accident lawyer credential. When you see car accident lawyer, you're seeing a marketing label meant to signal a heavy focus on motor vehicle collisions, not a different license. You're looking at how they market themselves and the kinds of cases they chase. That's why the spread and outcome feels confusing. Same license, different playbook. Here's the rub. Ads talk about car crash specialists, but Nevada doesn't hand out an auto-only specialty license. So the real gap isn't in titles, it's in what the lawyer does in the first 30 to 60 days and how they work rules that actually move money. Nevada runs on modified comparative negligence. Cross 51% fault and you recover nothing. Stay at 50% and you recover 50% of your damages. Hit 51% and it's zero. That binary edge is where cases swing. Fights break out over lane position, timing at lights, phone use, speed estimates, and whether a sudden stop was predictable. Evidence weight matters more than adjectives. Insurers lean into blame shifting, hinting that you were speeding, distracted, or missed a duty, because every percent they pin on you lowers the payout. If there's no quick preservation of black box data, no scene measurements, no camera pulls, your leverage drops fast. There's also a negotiation wrinkle many people miss. Defense costs used to chew into what was left for victims under some liability policies. Nevada closed that door with AB 398, which bans defense within limits policies and preserves the entire bodily injury limit for the injured person's claim. When medical bills are high, that change pushes carriers to think differently about tenders and timing because limits stay intact while their defense fees stack on their side. Adjusters generally run two tracks. If the file is messy, they throw a low number and attach faults to you. If the evidence is locked down, clean police work, hard data, tight witness statements, they tender early and avoid fees, interests, and a bigger verdict risk. And when alcohol is in play, punitive exposure can be uncapped, and many policies won't pay that damage. That creates personal financial exposure for the driver, shifting settlement posture fast when impairment is clear. So the meaningful question is about execution under Nevada's rules and whether your lawyer can prove it when it counts. Let's dig into 3 experience buckets that can actually change settlements. Smart clients ask a different question. Can your process protect fault, unlock coverage, and make injuries stick when a judge reads rules? There are 3 experience buckets that do that: fault and reconstruction, insurance stacking, and a real coverage audit. Medical proof that survives a judge, not just a demand letter. Miss one, and the money drops. Here's the tension. If you skip the coverage audit, you might miss UIM stacking and leave thousands on the table. If your biomechanical expert gets excluded, your injury link weakens and the offer shrinks. And if your fault proof is thin, you flirt with that 51% cutoff. Bucket 1 is fault and reconstruction. That means grabbing the EDR download fast so the black box preserves precise facts, vehicle speed, braking status, throttle position, seatbelt, and the delta V in the milliseconds before the impact. That data undercuts blame shifting and counters 51% comparative negligence arguments with hard numbers. You lock down a scene scan, mark crush profiles, and pull CCTV before it loops. You interview every witness while memory is fresh, and you map sightlines and timings with real measurements. Nevada negligence still runs through duty, breach, causation, and damages, and courts police expert limits tightly. Under Hallmark, the biomechanical expert must stick to forces and mechanics, how the crash loads the body, while only a qualified medical expert can testify that those forces caused specific injuries. Keep each expert in lane or risk exclusion that guts your causation chain. Bucket 2 is the coverage audit. Start with Nevada's 2550/20 minimum, then walk your UM/UIM under NRS 687B 145 because carriers must offer UM/UIM and stacking can apply if policies allow it. MedPay is separate, and the non-subrogation advantage means you typically don't have to repay it. So it funds treatment now without reducing what lands in your pocket later. Look for umbrellas at home and work. For rideshare crashes, know the TNC periods. The $1 million commercial layer is generally active only when the driver is en route to a pickup or transporting a passenger, periods 2 and 3. Liability hinges on the driver's exact digital status at the moment of the impact to access that policy. Hospital liens also matter, and under Washoe Medical Center, liens attach to the at-fault party's recovery, not your UM/UIM, explicitly protecting your UIM bucket and maximizing your net. Bucket 3 is medical causation. You match a mechanism of injury to the crash data, seat position, belt use, delta V, and force vectors. Your medical expert handles diagnosis and prognosis, while your biomechanical expert stays in lane on forces and tolerance. Use the collateral source rule so insurer write-downs don't undercut the jury number, and track treatment gaps so the defense can't call them breaks in causation. If you want a quick way to separate talk from execution, I've got a short call script that can pinpoint these exact capabilities. Let's put that into a simple call you can run today. Give me 60 seconds and you'll know who's real and who's just running ads. Use this as a quick call checklist. Read it word for word if you want. You're not trying to sound smart. You're testing whether they have a real Nevada plan, not just a brand name. Here's why this matters. If you pick by label, you can miss coverage that should pay you, and you can lose experts to admissibility challenges. Or if you drift over that 51% fault line and get nothing. A short call saves you months of stress and a smaller check. Start with fault. Ask, how do you secure EDR, scene scans, and CCTV within 2 weeks? Which reconstructionists do you retain and when? Listen for the steps, not the fluff. You want a plan for preservation letters, tow yard holds, data downloads, and a list of go-to experts who show up early, not on the eve of trial. Next, coverage. Say, walk me through UM/UIM stacking on my policies, MedPay access with no subrogation, and any umbrellas or rideshare layers you can trigger. They should ask about every vehicle and household policy, confirm whether your UM/UIM stacks, and explain MedPay usage without payback, and identify employer or personal umbrella policies. If a rideshare was involved, they should break down the coverage by app period. Now, punitive. Ask, if alcohol is involved, how do you leverage uncapped punitive damages, and do you assess punitive coverage exclusions early? You want to hear how they document impairment, preserve evidence from the bar to the BAC, and factor in that many policies won't cover punitives, which changes settlement pressure on the driver. Then, experts. Ask, which medical and biomechanical experts do you use to connect mechanism to injury without getting excluded under Nevada standards? They should separate roles, biomechanical on forces and mechanics, medical on diagnosis and causation, and explain how they aligned crash data like delta V with the injury narrative so that it survives a challenge. Finish with deadlines and procedure. Ask, what's your plan for Nevada's 2-year personal injury statute of limitations, the 3-year property damage limit, and the 6-month notice requirement if a city, county, or state entity is involved. You're looking for filing timelines, early notice letters, and how they calendar tolling and government notice traps so your claim never risks dismissal. If they can't answer cleanly with the Nevada specifics, keep moving. If they can, the name on the billboard fades and the method takes over. Keep this checklist handy on your next consult, and you'll hear the difference right away. What matters now is choosing based on results, not labels. The name on the billboard won't lower your faults, raise your coverage, or prove your injury. Methods will. Ask how they keep you under 51%, find every policy layer, and tie injuries to the crash with admissible experts. Using the 60-second script shifts the power back to you, away from marketing claims, so you can pick counsel on concrete, auto-specific experience that changes your recovery. Use the 60-second script on your next call. Ask for Nevada case examples that match your facts, same crash type, similar injuries, similar coverage.